Okay, hello, welcome everybody. Thank you for joining us here today at the International Water Resources Association webinar on groundwater and climate change, multi-level law and policy perspectives. As you probably know, this is a webinar hosted by the International Water Resources Association. The IWRA is an international network of researchers and practitioners who work on a multidisciplinary range of water resource issues. It's a nonprofit, non-governmental educational organization. As we were just discussing with the panel before everyone logged in, it's really a group that connects across so many different disciplines, different backgrounds. So if you have any kind of interest in water, it's a great place to go and to join us and to enter into a conversation that kind of transdisciplinary. It's really helpful, really good perspectives. IWRA provides a global knowledge-based forum for bridging these disciplines and geographies by connecting professionals, students, individuals, corporations, and institutions, everyone who's concerned with the sustainable use of the world's water resources. And we're so happy to have you here with us today. We have really a large number of people registered, and we're really excited to have everyone with us today. And we have a really great panel of a lot of academics and practitioners who have a lot of experience with this year's this webinar's theme of groundwater and climate change, and particularly around law. And as many of you probably know, these webinars came out of close collaborations that our researchers have had together. And in this case, this is with special issue editor Philippe Cullet, and who I know our first speaker, Ray Stefan, will explain a little bit more about the origin of the special issue and kind of how all these features came together and sort of the impetus for this research and for this webinar, actually. These presentations come from a special issue of Water International, our flagship journal, and we have worked very closely with our publishers, Taylor and Francis, so that all these articles are provided right now as open access. So if any of the presentations really pique your interest, go ahead and go to Water International, Google Water International Journal, and go right to the special issue. Download the articles, read them more in depth. Feel free to contact the authors and begin engaging with them, and go ahead and hopefully use these articles in your own work. Whether or not that's like academic and you want to cite them, or if it's going to be more practitioner-based and you can use these in the field. And these are also issues that are going to be subject in our upcoming policy brief. So please be on the lookout for that as well in the near future. And finally, I know some of you are probably already excited to continue the discussion after the webinar about this groundwater, climate change, and governance. And so you can go to our LinkedIn page and again, go to LinkedIn, search for International Water Resources Association, and we'll soon have a section where you can post your thoughts, post your follow-up questions, and really engage in these questions around groundwater. So please follow us on LinkedIn if you are interested. Today, like I said, we have a really distinguished panel here with us today, and they're covering a lot of ranges of both theoretical questions and more specific case studies. I think to be able to bring the two together in conversation will be really educational and really helpful for all of us. Our panel today includes Ray Stefan, a water law expert and consultant, Trevor Bickeretz, a professor at the University of Champaign-Urbana, United States, Professor Michael Kidd at the University of KwaZulu-Natal in South Africa, Owen McIntyre, professor at University College Cork in Ireland, and Birshar Odar, at the School of Oriental and African Studies at the University of London in the UK. So quite an international and wide-ranging group of panelists. We're very excited to have you all here today. So we'll just briefly explain the format of today's webinar. If you've tuned in the past, it's much like our other webinars. Each of our panelists will have a short 10-minute presentation with PowerPoints, and then at the end, we'll have time for questions, about 30 minutes for questions. So if you have any questions that you'd like to ask, either during the presentations or at the end, you'll see on the GoToWebinar control panel, there's a couple of different sections. One of them is questions. Go ahead and click on that, type your question, and then send it, and I'll see it and moderate the questions for our panelists. So occasionally I'll combine a few questions and be able to kind of direct who should be answering what. So go ahead and send those in as soon as they come to mind, and we'll go ahead and start engaging. And with that in mind, We're going to go ahead and turn the floor over to our first speaker, Reyes Stefan.
Yes, good afternoon, everyone. Thank you for joining the webinar. Thank you, Scott, for the introduction. It's my pleasure to introduce this special issue, and I would like to thank all the authors who have participated to the special issue. Even though, I mean, not all the authors are here, so as Scott said, you will hear part of the presentation of part of the papers, but there are more papers in the special issue, and I encourage you to read the other papers. This special issue was co-edited by me with Professor Philippe Cullet, so I have the pleasure to introduce on behalf of both of us the special issue. I would like to start by, let's say, introducing the topic of our special issue, groundwater and climate change. First, as a reminder on the importance of groundwater on Earth, groundwater represents 97% of the available fresh water. We have a great majority of people depending solely on groundwater to satisfy their basic daily water needs, about 2.5 billion people, mostly in arid and semi-arid regions. Groundwater represents a drinking water resource for 25% of the global population, not only in arid countries such as Libya, but also in a more or less humid region as Europe. And it's 65% of the global extraction goes for irrigation. And we will have, I mean, there is a paper in the, there are two papers actually in the special issue about irrigation, and one you will hear a presentation about drip irrigation now in the webinar. Basically, there's an increased pressure on groundwater worldwide, and notably in India, which is home to the largest number of groundwater users. Now about groundwater and climate change. Water is a transversal element at the heart of the climate change because, as we see, the majority of the impact of climate change are felt through alterations of the hydrological cycle. And what about the specific impacts on groundwater? In a drier climate, groundwater will receive less recharge, so we can face seasonal deficits in groundwater and eventually long-term decline in groundwater storage. On the contrary, heavy rains might cause groundwater-related floods. And heavy rains will not necessarily increase the recharge in groundwater because aquifers are recharged more effectively by prolonged steady rain. And groundwater, if properly managed, can represent a unique buffer during extended dry period, which we can see with the climate change going on. But the climate change international regime has had little focus on water in general, not to speak about groundwater. There is a limited scope, therefore, to link climate change policies with the regulation of groundwater. With the growing reliance on groundwater worldwide, it becomes imperative to forge more specific links between groundwater regulation and climate change governance. And this is what the special issue is about. The special issue represents a scholarly assessment of the state-of-the-art of law and policy perspectives on groundwater and climate change at the international, regional, and national levels. The papers presented in the special issue come from workshops organized within a partnership project between the Law, Environment and Development Center of SOAS at the University of London and the National Law University Delhi under the auspices of the UK-India Education and Research Initiatives. The objective of this partnership project was to address the specificities of India's situation and at the same time to better understand how groundwater and climate change regulation can be linked by studying the situation in other countries and at the international level. So far, both climate change regime and groundwater regulations have seen an increased attention on them, both at the international and at the national levels. But this increased attention has come separately, meaning that the climate change regime was looked at on one hand, and on the other hand, the groundwater regulations were looked at separately. So the special issue aims to bring together these two domains, and its unique characteristic. The content of the special issue it starts by focusing on groundwater and climate change at the national level. We have two papers for addressing India, and you will hear a presentation from Trevor Birkenholtz on the drip irrigation in India. Then another national paper concerns South Africa, and Michael Kidd is here also with us to present his paper. We then move at, let's say, a regional level. We have a comparison between British Columbia and England with Birsha Ohdedar, who is also with us in the webinar, and Owen McIntyre will speak about the legislation in the EU. We move at a regional level, and we have another regional level which is not represented here in the webinar. It's about North Africa, specifically Morocco and Algeria. And finally, there's a touch on the global level with a paper by Joita Gupta and Kirsten Conti and myself. So these two papers focus on the international legal regimes, both of climate change from one side and on international law and international groundwater law more specifically. And I mean, each paper has a different perspective. One speak about the legal pluralism in the groundwater law and the facing the the climate change regime, which is sort of unique under the UN Convention on the Climate Change. And my paper focuses more on what interactions can be found between these two legal regimes. The synthesis, the global ideas that we can conclude from these, in the special issue from all these papers, is that climate change and groundwater have continued to be considered and regulated separately, with little consideration of one by the other, whether at the national or at the global level. If we want a better consideration of climate change, we need to include more attention to environmental principles in groundwater regulations. We need a strong regulator for a proper implementation, because we often know that we have a very nice or very good groundwater regulation, but then the problems come at the implementation level. And there is also a need to a good knowledge of the resource for managing groundwater. This is indispensable, especially that groundwater is an invisible resource. The international developments of the climate change regime have so far focused on emissions, but the Paris Agreement adopted in 2015 has introduced a new approach with a strong position to adaptation, under which many water concerns fall. So it is, let's say, expected that the Paris Agreement has opened a door for a stronger consideration of water in general and groundwater in particular under the climate change issue. This is all what I wanted to say. I would like to leave more space for the speakers to introduce their papers. I hope that you will enjoy this webinar and be interested in our special issue, and we look forward to a lively debate with all of you. Thank you for your attention.
Thank you for that introduction, Ray. That was really helpful. You know, I really appreciated the way you were able to sort of put into context and frame for our audience some of the questions and the personal concerns around groundwater and climate change. You know, I know my own experience and background. You know, I mean, there's been a lot of talk about surface water and governance and regulation and laws, but groundwater has often sort of lagged behind in the governance regime field. So it's really helpful to kind of bring both sort of the biophysical questions around, but also to sort of set up where things are going. And I think, as you pointed out here with the Paris Agreement, it's going to be, kind of again spurring us forward to sort of additional routes for governance, additional attention being paid. So thank you for that introduction. I think it's really going to set up the rest of this conversation very nicely. Our next presenter will be Trevor, and see he's having a drink of water there. So let's go ahead, and he's ready. And,
Great.
there you go. Excellent.
Are we up? Great. Well, thanks so much, Ray, for that laying out the session and for ultimately organizing all of us and making this happen. And thanks, Scott, for organizing this webinar. I'm really grateful to be here and happy to be here this morning. I'll try to keep to my 10 minutes, and I'm going to be talking today about addressing groundwater decline via policy, but really through efficiency enhancements using drip irrigation. So as Ray was saying, about 65% of all groundwater withdrawals globally go to irrigation, but in India this jumps up to around 90%, and so it's really very central as a form of groundwater-led development, particularly in irrigation. And of course we all know, most of us anyway, that this has resulted in really serious groundwater decline. Most recently, between 2002 and 2008, NASA's GRACE experiment showed that northwestern India, where I'll be talking about today, experienced the largest groundwater depletion rates in the world, even though precipitation was above normal for that period. And so as we're talking about under various climate change scenarios, this is expected to worsen, particularly as we have more extreme events predicted in India with a simultaneous decline in catchment areas, actually. And so the one question driving my paper is, what's the policy response to this? Well, groundwater in India is regulated by individual states, so it's not a central government. It's not under the purview of the central government, but since the 1970s, the central government has produced a series of model bills, most recently of which Philippe Cullet has been involved in drafting, and his team. And so what the goal is for the central government to produce these bills that then individual states can adopt and adapt to their own needs. Thus far, it's only been, a version of this bill has only been adopted by about 13 states of 29 total, and not in Rajasthan, where I'll be talking about today. And so, from my perspective, this has led the central government to try to encourage addressing groundwater use and over-extraction by other means. And so, since 2008, they began doing this in earnest, first with the National Action Plan on Climate Change, which created a series of what they call missions. The first is the National Mission for Sustainable Agriculture in 2010, which I'll just quote here, recognizes the risks to Indian agriculture sector due to climate variabilities and extreme events. And one of the main ways to address this then is to encourage the adoption of technologies for enhancing water use efficiency, right? And again, recognizing that the central government has very little control over groundwater at the state level, and so trying to address groundwater use and ultimately over-extraction through new technologies. We get this in increasing earnest in 2011 with the National Water Mission that sets out an aspirational goal to increase water use efficiency at the plot level, meaning by individual farmers by 20%. And again, this is wrapped up and focused on enhancing climate resilience of agriculture. And then most recently, we have the National Mission on Micro-Irrigation, which the goal is to currently expand the 2 million hectares under drip irrigation in India today to 69 million. So it's a very, very highly aspirational goal, expanding that from 2 to 69. And the way that they do this is through providing a series of subsidies. So water managers are now talking about the 50-10-40 basis, which means that the central government provides 50% of the cost to subsidize the cost of a drip irrigation system at the farm level. The states provide 10%, and the other 40% is provided by farmers, often through low-interest loans. But the states are implementing this program, and they can also increase the proportion of their subsidy. And so we get a lot of variation throughout different states in India, where we'll all be talking about today. Actually, the Rajasthan state was subsidizing at 40%. So actually farmers were, during the period of my study, paying only 10% of the retail cost for their drip systems. Just a little bit about drip irrigation. For those of you who don't know, drip irrigation focuses on supplying water directly to plant stems or roots. And you can see in this picture, there are a series of plastic tubes that have small drip pores in them that allow water to be metered out directly to plants, and also for fertilizer and pesticides to be input directly into that drip water as well. And the focus here is really on efficiency. And so some studies have shown that water use efficiency can be doubled. And here the focus is really on what Boland's et al. Called technical efficiency, which is the idea kind of universalized by Kofi Annan, where the goal is more crop per drop. Okay, and so I'll come back to the focus on technical efficiency in a moment, and how this ends up skewing subsidy policies in a particular direction. And so also then third, they're really viewed as climate adaptive and viewed in, I think globally, as a linchpin in agricultural resilience under the increasing unknowns of climate change. And this is reflected in global numbers. Over the last 20 years, drip irrigation has expanded sixfold to include about 10 million hectares throughout the world. And India has been the leader in the adoption and expansion of drip irrigated area, with over 100-fold expansion in the last 20 years, and leads the world in with 2 million hectares under drip irrigated area. And as I noted, the goal of the state, central government, is to raise that to 69 million hectares. So really a massive increase. One challenge, and there are a number with drip irrigation that I want to focus on today, is what's called Jivan's paradox, and that's the idea that as when engineers develop new technologies that enhance the efficiency or conservation of a natural resource, in this case water, where we have drip irrigation that uses less water to produce more crop, that instead of leading to less water use, that actually leads to more water use. And it often has to do with the decreasing marginal cost of water compared to the amount of productivity. So you can imagine, as productivity increases, if you're using the same amount of water compared to the sale of that commodity, the amount of payment relative to the amount of produce is going down with respect to water. And so without new rules and regulations over, in this case, water use, we sometimes get farmers using more water rather than less. And so the question is, for me, which hasn't been explored in the literature, is why do we get this paradox? And many of the studies at the plot level in particular focus on efficiency in these technical terms, and that leads to its further adoption, because in the absence, or in an ideal sense, without doubt, in many cases, productivity increases under drip irrigation, and water use can decline if productivity is staying the same. And so what I argue then is that in the paper is that we really need to think about the political economy of adoption. And here we need to look at the farmer motivations for why they actually adopt, and that'll have an impact on whether drip irrigation leads to water savings or water decline. And so, as I said, I'm working in northwestern India, in the state of Rajasthan, which is arid and semi-arid. It's highly socially differentiated, so the spread of drip irrigation has an effect on other social structures like class and caste, and it's heavily groundwater dependent. About 76% of Rajasthan's irrigated area is irrigated by irrigation, and about 80% of its domestic water supply. And as I was saying, this has led to a severe state of groundwater overdraft. Most recent numbers, and I think the state stopped publishing these because they're so serious, actually, is about 400 million cubic meters per year. And again, historically, Rajasthan's had no formal regulation over water. And so I just have a few more slides here. In 2015 and 16, I conducted repeated and in-depth interviews with 12 drip irrigating farmers. And I also engaged in participant observation with them over a period of a couple of months to try to understand if what they do really matched with what they were saying. All of them purchased drip irrigation systems underneath the subsidy packages through the National Micro Irrigation Scheme. And on average, they paid about $2,300 for their drip systems. And now their land holdings varied, but within a range of about 1 hectare to around 3 hectares. So fairly small holdings by global standards, but decent sized by Rajasthan standards. And so just a couple of quotes from farmers about why they adopted drip irrigation. The first is, this is from 2015, we went in for the drip irrigation, or we went in for the drip to raise productivity. On average, we were getting double the production from previous flood irrigation methods, right? And so in that way, farmers are really adopting irrigation not to reduce water use, but to enhance productivity. And second, they're planning then for groundwater's ultimate depletion in their areas. And so another quote that's that seemed to be common across all 12 farmers that I interviewed is that water will be depleted beyond the solar pump. I'll come back to that in a second. In 3 years' time. After that, we'll either go deeper or sell. And so there's another subsidy scheme that allows farmers to adopt solar irrigation pump sets. And so what farmers are actually doing is during the day they're using their solar irrigation systems to irrigate, and then when electricity is available at night they're using available electricity to pump as well. And so it's actually increasing their overall supply of electricity, enabling them to both intensify production and bring more area under irrigation. I don't have time to go into those numbers, but that's essentially what's happening. So to conclude, is that we need to really think about Jevon's paradox, or it's also called the rebound effect. In order to get at that, I think we need to really focus on the political economy of groundwater that incentivizes farmers to intensify or expand production. In the meantime, we're going to see groundwater decline continuing rather than increased recharge rates. And so in this way, I think the overall lesson is that technologies like drip irrigation can't be thought of as politically neutral, and that they're really no substitute for kind of rational groundwater policy and new use regulations. And then in that way, we need to really rethink the character of these subsidies and think about how provisions could be added to the subsidies to not incentivize farmers to expand and intensify production, but to perhaps grow less water demanding crops. So just a few acknowledgments there. And in particular, I'd like to most recently thank all the participants at the 2 SOAS conferences that we went to who really made this paper possible. Thanks a lot.
Well, thank you for that presentation. That was really good, and I think that's something that a lot of our attendees and other panelists can probably reflect on both in their own work and where they live. I mean, there's really a tension, I think, in a lot of cases between increased subsidies, increased efficiency. Both of the efficiency is important, but yet forgetting to regulate groundwater, forgetting to put in provisions for its sustainable use, so overlooking that. So I think you really hit on some really key points, and I'm hoping that the rest of our speakers will kind of expand on that and sort of engage in this more. Just a quick reminder to all of our attendees that we will be having questions after the webinar is over. So if you have any questions that some of these presentations have already kind of given to you, go ahead and put them in the question box on the GoToWebinar control panel. It's on the right side of your screen, and about halfway down the questions. Just type them, I'll see them, and at the end of the presentation, we'll go ahead and ask our panelists. But right now, we'd like to hear from Professor Michael Kidd. He's ready. Have your presentation. Kim. Everything okay?
Presentation coming up.
Okay, excellent. That's what I like to hear.
Right. My computer's a bit slow.
I understand. End of the day, it's kind of tired. Been working hard. Does it seem to be coming up?
It's loading. Maybe I should start, and as soon as it comes up, I can.
Kind of gives a little introduction as it sort of loads.
Okay, it looks like we might be getting some action here.
All right, excellent.
So the central question that I'm asking in the paper, and we're looking at the connections between the law, climate change, and groundwater in South Africa, is what role law can play in South Africa in conserving groundwater and ensuring that groundwater can be used to address both current needs as well as the needs that will be presented by climate change impacts into the future. So in order to put the question into some kind of a physical context, South Africa is the 30th driest country in the world. So overall, the country is water scarce, although there are regional differences. Currently, the country as a whole is most reliant on surface water. In many parts of the country, that's either fully allocated, or in some areas, demand already exceeds supply. So overall, there really is looking like a situation where we'll need to augment current water supply. There's considerable untapped potential in groundwater. Groundwater currently is being used, but there's approximately 3,500 million cubic meters per annum that is still available, and that amounts to about a quarter of the overall water, surface and groundwater, that is currently being used. Now, if we look at official government policy, there are two of the policies that are the 2010 groundwater strategy and then the 2011 white paper on national climate change response, specifically identify groundwater as a potential future source of water supply because of the stress that surface water will experience because of climate change effects, not to mention the fact that it's already under stress as we only really starting to begin with the climate change impacts. But there's still gaps, significant gaps it seems, in scientific knowledge relating to the extent of availability, the recharge rates, and so on. The National Development Plan of 2013 doesn't explicitly refer to groundwater, but it plans that there will be about a third as much as currently irrigated that will be increased as far as irrigated land is concerned. So obviously that will add to the pressure on existing water supply and will provide yet a further role for groundwater to play in the future. As far as the relevant law is concerned, there's not time to deal with detail of that in the 10 minutes that I have available. But the relevant law is the National Water Act, and this is all explained in more detail in the article. In terms of that act, all water is treated the same, whether it's surface or groundwater. And a lot of the water that is currently being used is regulated, as it were, in terms of what is referred to as existing lawful use. So people who were using water lawfully in early 1998 or late 1998 are still able to use water on the same basis, and most water is currently being used on that basis. As far as new water uses are concerned, and water use is defined in such a way that it covers any activity that really impacts on water, including really for present purposes things like abstraction and storage, that is regarded as something that requires a license in terms of the Act, unless it is a kind of de minimis use, such as for domestic use. So any new usage of groundwater would require a license. And the licensing process requires a considerable amount of information, both technical and otherwise, that has to be gathered prior to decisions can be being able to be made relating to that licensing. And as I indicated earlier, there's still quite a lot of information relating to our groundwater resources. For example, the rates of recharge that still haven't been determined. So there's still quite a lot of research that needs to be done before many of the licensing processes can be carried out in such a way that they are properly in terms of the law and effective. So one of the things that has to be taken into account is the amount of water that is required for what our National Water Act calls the reserve. And that is the amount of water that's required for basic human needs, as well as the ecological reserve from that particular water system. So that a lot of the challenge really now is in respect of being able to determine all of that information upon which the licensing process rests. The law does provide for compulsory licensing, which is ultimately intended to replace the existing lawful use. The problem with the existing lawful use is that it doesn't rest on any of the scientific basis. So what the law provides is that where catchments are under stress, that compulsory licensing process can take place. But up until now, there have only been 3 instances of that process having been used, and it's a really quite a small amount of the overall area of the country that's been covered by that compulsory licensing process. One of the things that the law has to do in the context of increasing climate change pressure on the resource is look at and try to address the various threats to groundwater. And the 3 major threats to groundwater currently in South Africa are acid mine drainage, which isn't universal, but in certain parts of the country is a particular problem. And on paper, the law is adequate to deal with future events of acid mine drainage in terms of liability and so on. But there are gaps in historic coverage. So a lot of the acid mine drainage issues at the moment, the issue is who's going to pay for it, because the people responsible are often not around anymore. The second major problem, eutrophication and untreated sewage. This raises interesting legal questions as well as questions relating to compliance and enforcement, because most of the offenders in terms of untreated sewage are local government. So this is an issue of national government having to regulate local government and all of the sensitivities, political and otherwise, that raises. And the problem is it's often not simply enough for the local governments to comply with the law. That's obviously the final solution, but often considerable money and other resources are required in order for the sewage issues to be addressed properly. So it's not simply a question of the local government ignoring what the law says. Often there might be good intentions, but there's not enough cash, basically. And the third major threat, particularly in many parts of the country that are most arid and most water stressed, is hydraulic fracturing. And there's a lot of planning to carry that out in future. As far as I know, it hasn't yet commenced, but prospecting is taking place, and it looks likely. The government seems to be in favor of what they call an economic game changer. And there is law on paper, but as we've seen in respect of water management generally, there's quite a lot of law on paper that isn't necessarily working at the moment. So, I think there are considerable concerns about the potential of hydraulic fracturing in many parts of the country. But those concerns are turning into quite a lot of opposition, despite the fact that there is official government support. So my conclusions are, and there's more than just these, but again, in the interest of time, as we see increasing climate change stress on water supply in the country, there's a considerable amount of groundwater available for future use. On paper, the law is adequate to govern the use of the groundwater, to provide for equitable allocation, and to prevent threats to quality. but in many respects there's still a lot of information required, increasing research and future research required in order for those decisions to be made in a way that is coherent, both from a point of view of the law, but also economically, and in terms of the scientific questions that have to be dealt with. And ultimately, the proof of the pudding is in the eating. We have a number of existing laws that are supposed to regulate water use and water management in a particular way, but our experience thus far is not particularly encouraging. So thank you very much. I'm not sure whether the slides worked, so apologies for that. I think it was a resource issue.
No, I totally understand. And just as a quick reminder to everybody, we will have the PowerPoints available on our website after the presentation. We'll go ahead and get those uploaded in the next few days. So we weren't able to see Professor Kidd's right now, but if there's either you want to follow up with Professor Kidd or anyone else whose PowerPoint you see today, just as a follow-up, you can go right to our website. There's a webinar section, click there, this is the name of this webinar, and then you'll be able to find PowerPoints easily. And I really do appreciate what Professor Kidd had to say. That's really insightful and really helpful summary of what you're seeing in South Africa. And I think that a lot of those questions around, how is groundwater being used, how is groundwater being polluted, especially around fracking, especially around the acid mine drain, those are applicable in a lot of other case study situations as well. But I also think that you highlight, though, as a really helpful and interesting disciplinary divide between, the law being able to say, well, look, we've reviewed all the laws and they're adequate, they're great, but at the same time, we can look, as you say, proof is in the eating of the pudding, and we can say that we see some problems. So I think it's helpful to kind of be able to engage our social scientists and other types of disciplines to be able to kind of tease out a little bit more about what are these differences between why is law being on the books and why is the action on the ground just somehow different than what we're seeing. So I thought that was really helpful, and hopefully that'll be able to kind of pull through in some of our future presentations and for discussion afterwards. So thank you. Okay, now we are going to hear from Professor McIntyre. Go ahead and share your screen. There we go.
That working?
Yep, looks great.
Okay. Okay. I'm conscious of the fact that I have 10 minutes. I have 20 slides, which is a very bad idea for 10 minutes. Rhea spoke about the need for interlinkage between groundwater law and climate change law. And I want to talk about the role of traditional frameworks in environmental law for protecting or preserving groundwater, or at least ensuring rational use of groundwater. And I want to do this in the context of EU law by examining the ecological role of groundwater. I want to examine the jurisprudence of the Court of Justice of the European Union. There's very, very strict jurisprudence in relation to the maintenance of the integrity of protected sites, what we refer to as Natura 2000 sites, involving special areas of conservation and special protection areas. And this involves robust protection of the key ecological characteristics and features of such sites. Now, I would suggest that this represents a very significant opportunity for effective protection of related groundwater resources. But of course, those groundwater resources must be related in some way to the sites that are being protected. And I think this is important because those groundwaters would appear to receive really quite limited protection elsewhere in EU law, or at least limited protection in terms of their protection of the quantum of water in relation to abstraction and in relation to the threats of climate change. So the point is that EU nature conservation law may be employed here. It may not be employed directly, and we know this from the jurisprudence of the European Court dating back to 1991, that nature conservation law, the law on habitats and protection of bird habitats, etc., may not be employed to safeguard resources, natural resources required for purely human needs, so for anthropocentric uses. But the protection of groundwater-related habitats, for example, wetlands, would very often also result in improved provision of related anthropocentric ecosystem services, water storage, water supply, flood control, or recreational uses, etc. So I'm going to go very, very, very quickly through the relevant law. It's set out in detail in the paper. We know that groundwater, and I think Rhea has touched on all of these issues, a resilient reserve for human and other needs in the context of climate variability. But groundwater itself is vulnerable to climate variability, particularly changing recharge patterns. We need to focus on the role of groundwater in ecosystems, in the structure and function of habitats. Now, perhaps usefully, there is much uncertainty here, and the precautionary principle, which is central to habitats and species protection under EU law, becomes relevant due to that inherent uncertainty. Not just uncertainty as to the role of groundwater in the functioning of habitats, but also uncertainty relating to the impacts of climate change and climate vulnerability on groundwater, and therefore on its role, or thereby its role in habitats. Groundwater law itself focuses very much, EU groundwater law I should say, focuses very much on hazardous substances, on pollutants. If we look at Directive 8068, really we're talking about hazardous and non-hazardous substances. Again, waste management law at the EU level is relevant, hazardous substances law is relevant. We have legislation going back to 1976 on the discharge of certain dangerous substances to the aquatic environment. We have a host of specialist directives on mercury, cadmium, hexachloro, cyclohexane, that's a mouthful, carbon tetrachloride, etc., etc., etc. But again, pollutants. The Water Framework Directive, this large overarching piece of EU legislation relating to water resources, is again largely concerned with pollution, although we do have Article 4.1b2, which requires that member states take the necessary measures to protect, enhance and restore all groundwater bodies to ensure balance between abstraction and discharge to achieve good water status. Again, the Water Framework Directive is vague on detail. The European Court's jurisprudence is starting to attribute more teeth actually to the standards and the requirements set out in the Water Framework Directive, but that's a work in progress. So it's not that terribly helpful. We have a number of groundwater directives, but again they focus on discharges, they focus on hazardous and non-hazardous substances, so pollution rather than the protection of the resource and the quantum of water in the resource or controlling abstractions. Now, if we go to the Habitats Directive, this huge directive, this overarching directive for the protection of species and habitats dating from 1992, it does a number of functions, but what we're really mostly concerned with here is Article 6. And this protects this network, the Natura 2000 network of protected sites. And this is the very heart of the Habitats Directive, which employs an enclave approach to protect high-value sites, SAC, Special Areas of Conservation, and Special Protection Areas, which are bird habitats particularly. So it focuses very much on protected habitats and species, and the key measure for any activity, any project, any development that may threaten that site is that an assessment must be conducted, an appropriate assessment under Article 6.3. And I want to look very briefly at what's required there. Now, species protection outside of or independent of these protected sites is less certain. From Articles 11 and 12 and 13, 12 is to do with fauna and 13 is to do with plants. Member states are required to employ strict protection measures. Now, it's slightly different, and we're still uncovering what that means in the jurisprudence of the court, but those strict protection measures would normally involve environmental impact assessment, appropriate assessment or some form of biodiversity assessment, and of course the licensing of the activity. Now, the directive stipulates strict protective measures, and this may also be relevant, this discussion may be relevant for species outside of protected areas, but that is a leap in terms of the jurisprudence isn't yet there. Article 6.3, I won't read through it in detail, but any plan or project which might have a significant effect on a protected site must undergo an appropriate assessment and then may not be permitted by the national competent authorities, the national regulatory agency, unless or only after having ascertained that it will not adversely affect the integrity of the site. So ascertained, we'll see what that means, it's very strict. And the integrity of the site, what does that mean? We'll see again that that's a very high standard of protection. There are 4 stages, I won't go through them. We're interested in stage 2, which is the actual appropriate assessment itself in a strict sense. That involves 4 individual steps: the gathering of relevant information, prediction of the likely impacts, assessment of whether the impacts will have an adverse effect on integrity of the particular site, and then the assessment of mitigation measures. We won't go through these in detail, I'm afraid. We haven't the time. What we will look at is what does the jurisprudence of the court tell us? Well, first of all, in a very important case called the Vadency case, the court found that the competent authority may only authorize an activity that may impact on a protected site where there is no reasonable scientific doubt, where none remains as to the absence of such effects. In other words, the authority, before it can permit an activity, such as the abstraction of groundwater, or any other activity that might impact on recharge of groundwater, that you must ascertain, you must ensure, you must make certain, beyond reasonable scientific doubt, which is an extraordinarily high threshold of certainty, you must establish beyond reasonable scientific doubt that it will not impact adversely, will not affect the integrity of the site. If we think about the uncertainties, the technical and scientific uncertainties surrounding groundwater, that suggests that activities that threaten groundwater should not go forward. Again, there must be definitive conclusions commissioned in Italy. That again mitigates towards. I want to talk about one particular case, Sweetman and Borpanola, an Irish case to do with a motorway. But it was referred by the Irish Supreme Court up to the European Court. And the European Court employed several forms of reasoning: teleological interpretation of the Habitats Directive, looking at all of the terms of the directive and interpreting them holistically. And again, I haven't time to go into it in detail, but that really stresses that it stresses the constitutive characteristics of the site, that these must be maintained at favorable conservation status. And again, if you can establish that the groundwater plays a role, particularly any key role, in the structure and function of the ecosystem to be protected, this is terrifically important. Precautionary principle was also stressed under this. The precautionary principle itself became something of a reason for the decision. And again, it's not included in the Habitats Directive, but it's understood since Vadency has been central. Indispensable to its effective implementation, a sort of a form of the effet utile doctrine, filling gaps in the directive is the way the court appears to characterize it. So again, the uncertainty favors the use of precaution. The uncertainty surrounding groundwaters favors the use of precaution. This notion of a comparative linguistic analysis, the court looked at, what does integrity mean as a word? And they talked about essential unity, wholeness, soundness of constitutive characteristics. Again, that seems to allow for no de minimis exception, and again would suggest that anything that may take away a part of a key constitutive characteristic, such as connected or related groundwater, mitigates against any harmful activity being permitted. And also the court took what might be considered a purposive policy decision, talking about death by 1,000 cuts, or at least the Advocate General talked about death by 1,000 cuts. This seems to go beyond the traditional, the requirement for a cumulative assessment, and again makes it very, very strict. So it's not good enough to say this particular project, using a very small quantum of this ecologically significant groundwater, will not have an adverse effect, even if it has a small effect. And in Sweetman it was a very, very small, it was 3 hectares of 300 hectares, 1.5 hectares was it, almost 300 hectares of limestone pavement that would be lost. So very, very, very marginal amount. And the court said, or the Advocate General argued, and the court accepted to some degree that position, that might amount to death by 1,000 cuts and shouldn't be permitted. Thin end of the wedge. So the conclusions are that we have a judicially creative interpretation of the notion of integrity. It's very, very strict. It's very inflexible, very controversial. It's policy-driven. It appears to ignore the considerations of proportionality, which EU Commission guidance suggests should inform the application of precaution, etc. And in the methodological guidance on Article 6.3. We have to be careful of the breadth of the exceptional provisions under Article 6.4. That means maybe the exceptional provisions would be used, which of course really dispense with all protection. That would be my own concern about the strict interpretation. And the conclusions for groundwater. Groundwater may be established to be a constitutive characteristic of the site. If it's one of the key ecological features, if it can be linked to the structure and function of the site, if it's a key factor. So then even small-scale groundwater depletion may impact on the integrity of the site, the death by 1,000 cuts argument. The significance of the scientific knowledge of the ecological role of groundwater in the site is terribly important, but of course uncertainty could also militate towards its protection if it has a potential ecological role. Precautionary assumptions come in the face of uncertainty in relation to its role, and of course we also have uncertainty in relation to the impact of climate change. And those uncertainties, particularly in combination, would mitigate the use of precaution and this very, very, very strict interpretation of the notion of integrity. So where we have a site, where we have a groundwater source connected to a protected site, I believe this argument, in the light of the current jurisprudence of the European Court, could be very effectively employed. And of course that lesson may be true in other parts of the world, where ecosystems law, ecosystems protection often operates at quite a high level and is seen to be a priority within the range of tools that we have in the environmental toolbox, and may have a key role in protecting waters. Thank you.
Oh, thank you. That was a really great presentation, and I think really hit on some key points that we heard here earlier today. But also another context about how questions around how do we understand from a scientific and biological or physical way how much groundwater is there? How is pollution affecting groundwater? There's a lot more science there that still needs to be brought forward than maybe you see with surface water. So many more things that are not quite known, and that really brings forward the reason to have a precautionary principle and why it needs to be better used. But I also think it also highlights one of the key things that International Water Resources Association focuses on, which is the bridging the science policy divide between how do you take areas that the scientists who understand water physical characteristics very well, and then apply them to implementing policy and law. So I think it's very helpful. Now, I know that Rhea needs to leave here in just a minute, so I'm going to give her an opportunity to just say one last little piece before we move on to Virsha, our last presenter of the day. So Rhea, if you'd like to maybe kind of give your summary thoughts here a little earlier, any kind of ideas that maybe the panel and the presentations have brought up for you, would be great.
You didn't give me the time enough to think about an answer to this. Actually, from the presentations we heard, and of course from the whole special issue, I think it shows the importance of really considering both the groundwater and climate change together. And the examples we had from South Africa, India, and we'll hear from Virsha, and also what Owen told us. I mean, I think, let me go by order. From Owen's presentation, what is interesting is how a court can, let's say, interpret a law here. We are in the case in the EU, but as Owen said, it could be elsewhere also in the world. It's the interpretation of the court that is helping to protect groundwater, of course, in the case of ecosystems, but in the case of climate change. So this is not the law itself, but the interpretation, which is progressive and contributing to the adaptation of groundwater and the climate change consideration. The other examples of the drip irrigation. we all had the, and me myself actually, even before the workshops in London, I had the idea that drip irrigation was a very progressive technique to help save water, and then we understand that it's not really the case. And in the case of climate change and depletion of groundwater, it has to be reconsidered. The policy of developing drip irrigation has to be reconsidered. Michael has insisted on the knowledge of groundwater, which I think this is a must in the case of groundwater, because as we all know, it's an invisible resource. So the development of knowledge is even more crucial than for surface water. And of course, we have to know how the aquifer will react in the case of climate change, and then to adapt the laws and regulation. This is very important. But it does not mean, if we don't have the knowledge, that we don't need to apply a precautionary approach or a precautionary way of managing groundwater and implementing the law. I think these are the main points from what we heard, and I think we will find some similar points in what Birsha will tell us also. I mean, of course, there is also the international level that we are not touching here in this webinar, but it's also important that the international legal framework, and perhaps the international legal framework on climate change, evolves in considering also water and not only emissions in the adaptation. I mean, Paris Agreement has opened a door, but now we have to see how it will be implemented. Thank you, Scott.
Well, thank you for putting together, really helping us steer this webinar and steer the special issue and the code policy brief. We appreciate all your contributions and help with this and with IWRA. So thank you for being with us here today. Okay, our next presenter will be Birsha. And just as a quick reminder to everybody, again, questions are open, so it looks like we'll have about 15 to 20 minutes for questions. So go ahead and send your questions right now, and we'll go ahead and get to them at the end of the presentations. So, Birsha.
Great.
You all ready? There you go, looks good.
Is that on full screen?
It is not on full screen.
No. How about now?
No, it isn't.
Oh.
Yeah, I think you clicked the right button there. It looks like the presenter view. It's just not going to present.
Oh.
Worked fine earlier. Just do it as though you would do any normal.
Yeah, I'll just carry on. All right, so my paper was on groundwater law, especially reforms around groundwater law in British Columbia, Canada, and in England. The key questions that I considered for this paper. Hello? Sorry. Yes, the key questions that I considered in this paper were, one was what the key characteristics are in groundwater law or water law generally that are necessary to respond to climate change. Secondly, how the reforms in British Columbia and some of the reforms in England align with these characteristics that are identified in the paper. And thirdly, how other sectors, so the governance of other sectors, align with groundwater governance goals. And in this paper, I did a small case study of fracking, similar to what Michael talked about before in terms of fracking and groundwater use having a link, especially in the context of climate change. So I won't spend time talking about the links between groundwater and climate change, because I think that's been covered by other presenters. Sorry, are my slides coming up? Because it keeps going in and out.
Your first slide is up, but your other slides are not up.
Okay.
Are you clicking on them? Just if you,
I am.
yeah,
is the second slide up now?
Yeah.
Yeah.
Just come this way. It'll be better than nothing. It's fine.
Yeah, great. Yeah, so in terms of why I'm talking about British Columbia and England, one of the reasons was when we started planning for these workshops, the idea was to get perspectives from different parts of the world, and so that was the genesis. And I started looking at British Columbia because there was a new piece of legislation coming in at the time, and therefore that was initially chosen, and then England was used as a sort of counterpoint in this paper to compare. And you know, both these areas are not areas that we traditionally talk about in terms of groundwater or water, because we were mostly talking about places such as California or India or South Africa, etc. But there are things also happening in these sort of traditionally wetter countries around water use and water policies. So this paper focuses on these two particular areas, with mostly on British Columbia, with England used as a counterpoint about some of the reforms happening in both these areas. They're in different, so both of them are Commonwealth legal systems. However, there are some differences in relation to water, mainly that British Columbia has a system slightly based on what it is in America in terms of a priority-based system, in terms of first in time, first in right. It's not exactly like the American system where they have ownership rights over groundwater as well, based on that sort of senior priority. So the groundwater is still a crown resource, but if you're a more senior user, you have priority in that way. British Columbia also is a place where there was a severe lack of groundwater regulations, and there were a few controversies a few years ago around this, around sort of your usual bottling plants such as Nestle, and using up a lot of groundwater for free, and creating a bit of stir in the media, etc. And so there were good reasons for the legislative overhaul that happened in British Columbia in the last couple of years. As well as that, there were new technologies that are coming in, such as fracking, which I talk about in the paper, which have an impact both in terms of climate change and groundwater. So in terms of, initially in the paper, I go through a bit of a literature review on what kind of things groundwater law needs to be putting into new groundwater laws to respond to climate change. And I draw a lot on sort of groundwater governance literature from the FAO and climate change adaptation literature. So here in this slide, I have sort of 6 different aspects which were identified as key things that groundwater laws need to reflect in responding to climate change. Firstly, having some flexibility to respond to changes in circumstances, changes in water, water availability. Secondly, in terms of having a bit more of a participative approach, in terms of to enable more informed decision making, including participation in terms of information gathering, data gathering, etc. So these are things which other speakers have, of course, also spoken about. Thirdly, an effective legal framework. That's a pretty broad sort of statement, but basically to have a legal system which is operating in a way to facilitate climate change adaptation rather than hamper it. Third, as well as having things like enforcement, adjudication, etc. Fourthly, recognizing that ground and surface water and groundwater are linked, something which a lot of regimes, including the ones I looked at, have historically not done because they've been sort of land-based groundwater rights. As well as that, protection of groundwater through conservation of groundwater as an important source of water in the context of climate change. And lastly, in terms of linkages between groundwater law and other areas of law, so that it's not just groundwater that exists in a vacuum, but other areas of law have to also be aligned with some of the groundwater governance principles. So moving on into British Columbia, and the main legislative change that has happened is this Water Sustainability Act 2016, and that is a framework legislation, so some of the sort of detail will still come by way of associated regulations, which will flesh out the governance of groundwater. But what the framework legislation does is sort of create an overall picture of how water and groundwater, more specifically for the purpose of this paper, will be governed. So it is, as I said, a major overhaul of the water regime. Groundwater was sort of neglected for a long time in terms of regulation, which created a lot of issues. So now finally there is a groundwater licensing, as well as sort of fees for groundwater, which have been implemented not for domestic use, but for non-domestic use. You must make beneficial use of water to get a license, and even though that was the case before, now there is a specific sort of legislative criteria as to beneficial use, and if you don't use your license for 3 years, it gets revoked. However, it does uphold the priority allocation system that I was talking about earlier, which is first in time, first in right, so that those who have the most senior license will get allocated priority. So to move on to a bit of analysis of this Water Sustainability Act in reflecting on the earlier sort of aspects of groundwater law in terms of climate change. Yeah, so this first in time, first in right allocation system, as we can see, is kind of a rigid system. If there is water shortage, it gives priority to senior license holders, which isn't really in line with sort of more scientific, equitable, or ecological perspectives. However, what the Water Sustainability Act tries to do to sort of counteract some of these, the worst aspects of first in time, first in right, is through having mechanisms such as temporary protection orders, which can be issued at a regional or specific area which is facing, say, a water quality or water availability issue. And at that time, they can issue this temporary protection order to stop abstraction or to vary licenses. Included in that is that you wouldn't have to give compensation if you are issuing a temporary protection order to the license holder, so that removes some of the budgetary pressures for the government in terms of taking some of these measures. Licenses are also to be reviewed after a period of I think it's 30 years that licenses get reviewed, which is a long time, but it's still so it would be around 2040 for people applying initially, and when the Water Sustainability Act came into being. However, so it means that at that stage, licenses can be reviewed if a particular area needs to scale back its water use. So some of these flexibilities to counteract the more rigidity of the first in time, first in right allocation system. Sorry, just to say on that, so right now, because there was no water licensing sort of system before this, there is a process of grandfathering in every person's water use, which goes on for about 3 years, and at that stage, you get your license 3 years after the act came into being. So moving on to participation, this was a strong emphasis on this act in terms of having something called water sustainability plans, which will be coming in through regulation, but essentially regions can form partnerships between local councils, authorities, and other bodies, apply for a particular area to develop such a plan, and so it would be, here there's scope for example, First Nations governments to form water sustainability plans with local authorities. That is actually something I've put at the bottom that I haven't looked at in depth in this paper, is the issue of First Nations or Aboriginal rights, but I do put some references in there for further reading on that particular issue, because it is it's an issue which is particular to British Columbia or to Canada, but isn't covered in my paper. Thirdly, in terms of protection, or protection and conservation for the first time in this act. So now you have a sort of a link between surface water and groundwater recognized together through the term environmental flow needs. So upon application of a license to surface or groundwater, the decision maker must consider the stream or aquifer's hydraulic connectivity and consider sort of the connectivity between surface and groundwater. So, of course, details will follow in terms of legislation, etc. But there is at least an overarching idea that surface and groundwater are connected. Following on from that, in terms of knowledge and information, British Columbia is not sort of way behind in terms of knowing how much groundwater use, how much groundwater use has been taking place, etc., because of a lack of regulation or lack of governance. So now there's a sort of catch-up exercise in terms of making users submit data, non-domestic users submit information and data on groundwater. And then finally, in terms of linkages in terms of other areas of law, there's something called the water objectives, which is introduced. So the water objectives will basically mean that there could be area-specific objectives of water by way of standards, qualities, etc., which all decisions around land use, mining, infrastructure would then need to consider these particular objectives on water. So that creates a form of being able to link it to other land uses and other areas of law. So moving on to just briefly in terms of England, England very different. We've had major aspects of groundwater law for about 50 years. A lot of that has been sort of unscientific abstraction licenses, but since about 2000, the EU Water Framework Directives have driven a more ecosystems-based approach, including catchment-based management strategies for abstractions, including time-limiting abstraction licenses. So again, moving away from the senior licenses in perpetuity, which was there before, introducing things like time-limiting licenses. Some of the more recent reforms have again been this struggle to be able to review or vary old licenses, introducing things like no compensation on variations of abstraction licenses for environmental damage, introducing in some new reforms in 2016, which are actually to come in 2019 to try and new licenses to be linked more to availability of water or to environmental flows rather than being time limited. So again, introducing more flexibility in abstraction licenses to cope with changing circumstances, including under climate change, as well as changing demands. Introducing things like risk-based catchment approaches, which means that licenses can be based around sort of in a more dynamic way. So if a particular area is facing particular shortage of water, the licenses can then be reviewed then, and you don't have to wait till a longer time period. So again, what I say in the paper, for example, is some of these things could then be picked up in England, in British Columbia as well, in terms of building on their regulations and building through this new Water Framework Act that they have. So I'll just move on to the last part of my presentation, which is on the coherence of groundwater responses, groundwater and the regulation of fracking. So I looked at fracking for a number of reasons, but one of the reasons was because to see a particular area where a particular area of governance, groundwater governance, which is not quite aligned with broader water sustainability goals, etc. So in British Columbia, for example, there's you have special provisions for groundwater use just for the fracking industry. So a single window mechanism, an overarching regulator being different to the Ministry of Environment. Therefore, there's criticism of some of the big gaps in terms of how groundwater is getting regulated just for this particular industry. So overall, it's being regulated by a different industry, being the Oil and Gas Commission. It's not as stringent as it would be under the under a normal water abstraction license. And it's a similar case, I'm saying, in England, where although fracking hasn't developed to the same extent, legislation in England as well is starting to have instances where it's not using the same, for example, to give the example on the slide, the Infrastructure Act that was brought in, there was a proposal to prohibit fracking in key groundwater protection zones, which is recognized by the Environment Agency or by the existing groundwater regimes. However, they used a different term rather than using the term that was defined, which means that you again have this incoherence between existing groundwater protection or existing groundwater goals and a new regime being set up just for a particular industry. So just to conclude, since I've gone over 10 minutes, I think overall in the paper, what I try and point out is that British Columbia's Water Sustainability Act overall is quite a progressive, climate responsive, and a long overdue overall of the water regime, which now needs to be built up upon through regulation. There are some gaps which I point out in the paper and issues that need to be addressed, but overall that was the picture that I was trying to give. In England, it's a different place that England's at. There isn't this sort of big overall, but some of the things being introduced could also be built into the WSA through things like dynamic reviews, greater public information, etc. And in both jurisdictions, you see the struggle between groundwater rights, which are historical groundwater rights, to cope with changing climate. As well as this issue of coherence, which I touch on through the fracking case study. Thank you.
Thank you. That was a really great presentation. I think it really touched on a few of the key points and sort of gave us a different viewpoint on some sort of water, energy, food nexus questions that might have come up. I know we've talked a lot about agriculture and groundwater use. And Professor Kidd touched on some questions around acid mine drainage. But by getting into the fracking a little bit deeper, that really helped to sort of bring it out. And also, since I'm right here in Vancouver, very interested to hear about British Columbia's changes. So that was always helpful. Okay, everybody, we have about 5-10 minutes left, and a few questions have already come in. What I'd like to remind people is that everybody on our panel is very friendly, trust me. And if you have any small question to follow up on a point with their presentation or something you want to question about a slide or anything like that, go ahead and feel free to look them up on the internet and drop them a quick email and follow up with them that way. That way we don't need to get everyone discussing and thinking, talking, and taking all the time on a small issue about a slide or anything. But one of the questions that have come in, and anyone can answer this maybe as they sort of want to, but I hope I'm getting the question right here. But what are some indicators around groundwater, indicators and parameters around groundwater usage and climate change adaptation and mitigation? Anyone wants to respond to that?
I could just say something quickly on that. I think one of the proxy indicators that especially agricultural scientists are really looking at is looking at soil moisture. And so some of the new satellite data, for instance, can drill down, euphemistically speaking, to a couple of meters to try to get a sense of the links between groundwater and soil moisture, where soil moisture is considered to be extremely important for resilience of agriculture to climate change, thinking about that it's a response to both groundwater and water use at the upper zones. And so it's a way to get a broad scale picture without having to do field level studies to get, again, a broad scope of things. So that would be one, I would think, is a focus on soil moisture as a proxy.
Okay, excellent. Does anyone else have some input, or want to go to the next question? On the next question. Okay, this is specifically for Professor McIntyre, but I thought it was so applicable to everybody, who since really one of the themes, I think, of this webinar really has been a kind of how to bring together science and policy. So, the question is, how do you overcome questions of scientific uncertainty of groundwater, along with the questions of scientific uncertainty about the impacts of climate change, and then how do you apply those in a policy setting? So, we can start with Professor McIntyre, but if anyone else wants to weigh in at the end, that'd be great. Hey, Professor, if you could turn your microphone back on.
To address those two issues in the context of EU law, you don't actually have to address them if you're seeking to protect groundwater. What you have to do is, if you're proposing a project or an activity which may adversely impact on a groundwater resource, you have to dispel the scientific uncertainty, if you understand me. I mean, what you need to do is, you need to establish, it's a terribly, terribly strict standard. And it's one of the reasons that we are now seeing in the practice of environmental law in Europe that where you can connect any issue, be it to do with marine or coastal protection, be it to do with, activities connected with waste management, if you find a connection to a protected site that's protected under the Habitats Directive or national transposing measures, you have a trump card if you wish to protect it, because the standard for anybody who's proposing a new activity, a development project, any new activity, any new development, which might in any way impact on the integrity of that site, is that they must establish beyond reasonable scientific doubt that their project will not adversely affect the integrity of that protected site or of any of the protected species connected with it. Now that's an extraordinary thing to ask in the context of biodiversity, because establishing beyond reasonable scientific doubt in terms of, as a colleague of mine who's worked in this area for the last 30 years, who's an ecologist, the last 30 years has been very, very intensive research around ecosystem dynamics, and we now know something. We now know that we don't really understand very much about ecosystem dynamics. And so scientific uncertainty is inherent here. And it almost works at two levels. It's inherent particularly in groundwater. If groundwater is connected or has a role in ecosystem structure and function. But it works almost on two levels. A, what is the role, how significant is groundwater in the functioning of an ecosystem? But B, what might the effect of climate vulnerability be on that groundwater? And then on its possible or potential role in ecosystem structure. So the point is that the activity which may threaten, if it's a new activity and it seeks licenses, permits, etc., if it's a new activity, in EU law it has to undergo, if it threatens anything, it has to undergo screening. So if there's a road threat, it then has to undergo appropriate assessment. And that appropriate assessment requires that you establish beyond reasonable scientific that it will not impact the integrity of the site. And we know that the standard of proof beyond reasonable scientific doubt is extremely strict, but also what we consider to be a threat to integrity is extremely strict. The Sweetman decision was to do with, I think it was around 1.5 hectares or 2.5 hectares out of over 200 hectares of limestone, reasonably inert ecological proof. So of course there's a great deal of literature, academic literature, looking at that particular decision, talking about it being an obstacle to development, etc., etc. And it does provide, it does put, it can be a major obstacle to development already, for good or ill. But if you're seeking to protect groundwaters, this is immensely, if you can connect better than the structure and function.
Excellent. Thank you. That's a good, clear answer. Does anyone else have anything to add before we wrap up here? Okay. Well, we're at the amount of our allotted time, and so at the risk of kind of going way into overboard, we'll go ahead and wrap up. But give it a chance for everyone to kind of go back around and give any final concluding thoughts and just summaries and about how the webinar went and anything else you have to kind of add to this conversation. We'll go ahead and Okay, so this would be a clockwise order from Michael Kidd on my screen. Professor Kidd, if you'd like to add anything at the end of the presentations here.
I think it was interesting to see how a lot of the themes in different areas, geographical and maybe areas of thinking, are similar, and that even if the way in which things are regulated are not the same, or the ways that are not the same, one can pick up lessons from other jurisdictions. You know, I think when Trevor was talking about regulation of groundwater use in India, you know, I was thinking about what is happening from a physical point of view, and I'm thinking, well, you know, the regulation could follow the sorts of things that we're doing, at least on paper, in South Africa. So, you know, it wasn't a case of drip irrigation being a problem. It was, you know, let's carry on with drip irrigation, but regulate in such a way that people aren't extracting too much water to do the drip irrigation. Right. And, you know, the kind of question that's going around in my head is that we've got a limited amount of water, and the planners in the country are wanting to irrigate 500-something million more hectares. How's that going to happen? Well, maybe we start using more effective ways of irrigating, in which case the pressure on the existing water supply reduces. So I think, you know, the basic point is, you know, let's look at what other people are doing. There's lessons everywhere.
That's great. Thank you. Birsha? Unmute yourself.
Yeah, no, thanks a lot for organizing this, and yeah, I think there were these lessons from each of the speakers. I think one thing that Michael touched on was on, you know, having nice laws on paper, and then how do they actually get enforced, and that was something that even in, obviously in the South African context he was talking, but even in the English or British Columbian context, that was an issue that I was also thinking about. For example, in the UK, with a lot of the cuts that have happened to the government, having a system which requires a more responsive or dynamic regulator, which some of the reforms require, but at the same time having a regulator or having some of the departments, the key departments, being underfunded or having massive cuts to their funding, actually mean that the same thing happens, that you have nice laws on paper, but whether they actually get are effective in the next 10 years will be an issue going forward. So that's something for us to all think about as well.
Yeah, just briefly, I think something that's interesting across the papers is this. One is that we have these, where we do have rules and regulations, that they were evolved and created under a different kind of use regime, as well as a precipitation weather moment, right? And now they're institutionalized and very difficult to change. And so with Owen's paper, you know, thinking about how can we use what we have to, or that have been developed recently, and innovate them in other ways, and across the other papers as well. You know, even here where I am in central Illinois, a breadbasket of the U.S. with historically rich agricultural land, we've been facing droughts. And because we have a riparian water law, there's no rules over farmers being able to pump groundwater. Never needed to historically. So they're going in for groundwater irrigation. And so I see a lot of similarities between groundwater-led development in general in the global south and what we're seeing in other places. You know, and clearly we need to do something along the lines of what Michael's talking about in particular, before the horse is out of the barn, so to speak.
That's a good point, a good perspective on that. Kind of draw these papers together. Professor McIntyre, you got anything to add?
I agree with the comments, the concluding comments that we've had from everyone, and I won't repeat them. The one thing I would welcome, I think, is there does appear to be greater attention, greater focus on groundwater, and obviously that's very appropriate when we look at, you know, the extent of human dependence on groundwater that we should have. And it comes back, say, to your point, Trevor, that we're we're looking at groundwater perhaps in an outdated paradigm. Yeah, you know, a lot of the regulation relates to an outdated paradigm, but we really should be focusing on groundwater when we consider its significance. It's ironic, in fact, that at EU level we have very little groundwater protection law directly. We have to maybe look in other places at nature conservation law to try to protect groundwater resources. That's quite ironic when we have such extensive human dependence on groundwater, that we have to dress it up in a nature conservation context, because we have very, very little protection. No, that's in a bigger, that fits into a broader context that I try to deal with in my own paper, that actually at EU level we're completely unprepared for climate change, for water scarcity and drought and water scarcity due to climate variability. We really have no legal frameworks in place for those at all. And so we'll use what we can. So if we rely on groundwater, or if we rely on nature conservation, as lawyers, we'll use any tool that comes into our hands. Obviously, that's where we're not beyond being utilitarian in that regard. But yeah, it's great to see the focus, the attention on groundwater.
Great.
Excellent. Well, thank you so much, everybody. Just in conclusion, I'd really like to thank everybody on the panel, and thank you for joining us and all your thoughts here today. Great presentation. So thank you, Ray Stefan, Chair Smith. Thank you, Trevor Berkowitz, Michael Kidd, Ellen McIntyre, Bishara Odar. Thank you so much for joining us and helping us here today. Just a reminder to all the audience members that some of the panel and IWRA are on Twitter, so if you feel free, go ahead and look them up and follow along and see what their news work is and what their career is doing and what their research is going at. And if any of these presentations left you interested in learning more, you can go ahead and reminder to check out the special issue of Water International and the open access articles that have been provided by Taylor and Francis, both of which are easy to find. Just go to Google and search for Water International and you'll quickly find all these articles. And you can also be on the lookout for the policy brief that'll be coming out quite soon. And please follow up on the LinkedIn page, which will be a good resource for anyone who wants to continue having these kind of conversations and to learn more and discuss more about groundwater and climate change and governance. I really hope that all of you found the insights provided today by the panel to be just as helpful and fascinating as I did. Give me a lot to think about, the material that I'll be working with and working on in the next couple of weeks, my projects, and so I hope it helps you as well. A lot of creativity and good thoughts and continue moving yourself forward. Just to remind you again, this webinar is brought to you by the International Water Resources Association. We're an over 40-year-old nonprofit, non-governmental educational organization that focuses on bridging disciplines and geographies and connecting professionals, students, individuals, corporations, institutions who are all concerned with the sustainable use of the world's water resources. So if you're interested in knowing more about the association or becoming a member, please go to www.iwra.org and you can find all the information you need right there. So on behalf of the whole IWRA office, thank you for tuning in today and joining our webinar. Thank you.